Everyone. Hope you're all well. So yes, a year, well, more than a year down the line, we're just going to have a refresher on COVID insofar as it relates to construction contracts, not in the medical sense. So what we're going to look at is how to deal with claims under both NEC and JCT. Also, the issues that we're going to be looking at will apply in a general sense to bespoke contracts and any other contracts, ICHEMI, FIDIC, that you might be working on. I'm going to look at steps to take now and things to consider generally. Before we go any further, what I do want to kind of think about is safety and reputational issues. That's not the focus of today's webinar, but that probably comes top of any business's agenda as far as COVID is concerned. The real focus for me today, though, is still important, but probably third, fourth down the list is the money and any time, which obviously time is money, and of course the liquidated damages, same point. So from the safety and reputational point of view, what I want to say is follow the guidelines. We're all used to those. What I would say is, it seems to me, talking to my clients, that the construction industry has done an absolutely fantastic job of continuing working and keeping construction going as the government has wanted you guys to. So you've done a fantastic job there through the pandemic. And also, I'm not hearing of many outbreaks of COVID on sites or in construction companies' offices, which again is absolutely fantastic, because I know that, you're all pretty much, working, pretty much as usual, subject to the guidance. So I think that, that really shows construction industry in a good light. So the guidelines have pretty much been the same from the start when they were issued last March. And, it pretty much has been subject to the distancing, all the various health and safety measures. Construction should continue as usual, work from home if you can. So, that applies to some, office-based individuals, but, generally, we've been back at site working. Keep track of the changes. They're not really changing very much now, but all of this involves value judgments, so the key thing there is to document them. Now, the value judgments are from a safety and reputational perspective, but what you will see is, in terms of submitting claims for extra money, etc., extra time, it still involves value judgments, so it's still really important to document them, and we'll come back to that. The legislation, just very quickly cover this. So that first bullet point is, the legislation, it was first introduced end of March last year. It was being reviewed every 21 days, but the key point for us is that you were allowed to travel for the purpose of work where it's not possible for an individual from work from the place that they're living at. So that was what allowed all sites to continue. So just looking at what we saw initially when the government introduced the initial lockdown back in March, was we obviously saw the government legislation. We also, there's also issue of operatives being sick, and closure of suppliers, and clients closing sites. So we kind of saw a real mixture of that. First of all, the government legislation closing sites, that never actually happened. Obviously, there's always a possibility it might, but 12, 13 months down the line, it looks extremely unlikely. That there was always the possibility, 13 months ago, and you may recall we had a bit of a funny few weeks, March, April, where we we kind of weren't really clear what was happening. We thought we were allowed on site, and that generally was happening. I had a couple of projects where contractors for who were working for some developer clients of mine pretty much abandoned site. They claimed on the grounds of COVID. We suspected not, but generally sites kept going. The difficulty we all had was that the suppliers were all closing. So that was effectively bringing work to a standstill and caused problems for a few weeks, not too long, I don't think, though. So I think the real issues now are, and we did have clients closing sites as well. That tended to be more for a couple of weeks just to get health and safety measures in place. We also saw sickness for some site operatives, and I'm going to give you a couple of scenarios there to look at it. Now, what I'm focusing on this afternoon is really the mechanisms that you need to put in place, the notices that you need to issue whilst you're on site if you are impacted by COVID, and also some tactical things to think of, particularly with JCT, because if we're looking at COVID as a force majeure, something that neither party could anticipate, then generally you're only going to get an extension of time. You're not going to get loss and expense. So, we're going to look at some other issues and that you might want to consider with a view to claiming, so that you get not only an extension of time, but also your loss and expense. Before we go on to that, though, I just want to look at a couple of points. The first is the date of your contract. So, of course, 11, 12, 13 months ago, when the legislation was first introduced, we were all embroiled in a number of contracts, and we had an issue then, which you may still have, because of course you may still be working on those contracts, or you may have finished working but may be pursuing claims related to COVID. So we have an issue as to, back in March, COVID delays that were experienced then, and any time, since then, are you entitled to claim under them? So what you need to bear in mind is when you entered into the contract. Certainly, contracts entered into prior to 2020, I think you're probably okay. Contracts entered into January, arguably, you were aware of COVID, because of course it started to come into the news in January, February ditto. Certainly contracts that you were entering into in March, we were aware of COVID, so you are going to struggle to come within clauses such as force majeure, where you're saying that the claim is based on an event that you couldn't reasonably have been aware of, which means that hopefully since March, any contracts that you've entered into subsequent to March last year, hopefully you have been making provision in those contracts for any COVID related claims, because probably force majeure in the JCT, probably also the kind of similar clause in NEC are not going to assist you there. So just be aware of that. And just as we're going through this and talking about the notifications and the claims that you can make, think about this distinction between contracts before March last year and contracts subsequent that have been entered into subsequently, and bear that in mind with your drafting. Otherwise you might find that you're taking the risk of COVID. And it might be that in negotiations, clients are saying, well, that's only fair and reasonable because, contractors should now be aware of the risks. should be able to deal with them. So that's the first point there. The other point with regard to all of these scenarios is that apart from the notification that we're going to look at, and apart from determining which provisions apply, you also need to show that COVID has actually caused the loss that you've suffered or the delay that you've suffered. It's not just a case of saying a COVID event occurred and therefore I'm entitled to an extension of time, because it might not be that COVID has actually caused it. So that's what we're looking at. What has actually caused the delay? What's caused the additional spend? Now, these issues are really fact specific. It's a legal issue, but you need to understand the facts. You also need to document it as you go along, because if you can document that you are delayed because of COVID, and that's not disputed by the client, then that's really helpful if there's a debate at the end of the project as to whether you're entitled to extra time or money relating to COVID. So do document it, send an email. That's what I mean when I say document it. I don't mean just put a note in your diary, because the whole purpose of this is to, if necessary, have a debate at the time with the client. And of course, the ideal scenario is that you notify that COVID is causing problems and that it's their liability, and they either don't respond or they come back and agree, because then later down the line, if a dispute does arise, we've got evidence to show that there was no dispute at the time. So do document it, and do think about this causation issue. So, for example, I currently have a matter where a contractor's saying, we were delayed, we should have completed the works in December 2019. We moved into 2020 and we were delayed by COVID. And what we're saying there is, well, actually, no, the delay was caused back in 2019. So it was nothing to do with COVID. And the fact that contractor, you were then, caught by COVID, that's wholly down to the fact that the initial delay was caused by you. So you can't then say further delay was caused by COVID itself. Another issue that we're seeing is, for example, sickness of site operatives. We've got a matter where it's actually the client who pretty much closed the site and stopped works because other operatives that it had engaged ended up all going off sick, because the whole group of them were ill with COVID. And we've got a couple of points there where what we're saying is, well, that's not COVID itself that has caused the delay. It's the fact that the client, in this case, had to close the site. So that's the first point. And even if it was because of a COVID incident, it looks to us, arguably, as if it was because somebody wasn't managing the COVID requirements properly, because a whole group of people caught COVID on site. And it's the only instance I've come across. All the other instances, and talking to my clients, all the instances of COVID that they've had have been individual instances where, typically they can trace it back to having caught it from a relative who has had it because they work in a hospital, or who, works as a teacher, all that kind of thing. So, we're sort of using not using that as evidence, but what we're saying is, that it is really rare to find that you have an outbreak on site, and therefore, it is possible. And you guys probably, hopefully will be nodding and saying it is possible to operate a site and for people not to catch COVID from working on site. They might catch it from home or from being in the pub or whatever, but they're not catching it on site because it's possible to have measures in place to prevent it. And so what we're saying is, in this instance, it hasn't been as a result of COVID, it's as a result of poor management. So, these are the things you need to look at, but they're also the arguments that you might be facing in defence of your claims. So just think about that causation issue. One of, if we go back, and this is probably just for a fairly discrete period, but of course what we saw was the closure of all the suppliers in end March, beginning of April. So again, if you were hit by that, what you might find is that your client's requiring you to provide evidence that your particular supplier closed, but also evidence that you tried to mitigate that, so that you tried to, look around, find another supplier, and that, in actual fact, it wasn't possible because they were all closed. Instances where client closes site, as I've said with mine, look into it. If you're delayed, or if you're stopped working due to a third party, whether it's a client, another contractor, whatever, don't just take it as read that that's a COVID reason. Look into it. Is it bad management? Is it actually, on one of mine, another one of mine, what we're saying was that the client was delayed anyway, so it wasn't COVID. COVID was sort of a convenient thing that happened, but that the real delay had already occurred before the COVID incident. So, look at all of this. Don't just take it, for granted. If somebody says this is a COVID situation, look at, why it occurred. Was there any delay, any pre-existing delay? What, is there bad management? Because I think these are all really, really key points. And in some instances, the courts are potentially going to be looking at this because, of course, we haven't had a pandemic for a long time. It's really, really rare to have force majeure events. So, these issues might, there's a really good chance they're going to come up in court, and the courts are going to be looking at things like, if a client closes a site, was that reasonable? Was it COVID? Was it something else? So, it's kind of interesting times for the lawyers, but I guess for you guys, what you need to know is, how to protect yourself as you, go through a project. So in terms of NEC, hopefully we all know that if you're looking at any time or any extra time or any extra money on a contract, you're looking at a CE, a compensation event. Compensation events are all listed at clause 60.1, whole raft of them. There are others dotted around. So for example, the X clauses, as set out actually in that third bullet point, change of law is a compensation event. So there are a few dotted about, but generally you'll find them at clause 60.1. What I always say in these webinars is, when you're notifying a compensation event, have a quick look at clause 60.1 just to make sure that you've covered them all. There's always the inclination to use the ones that we use day in, day out. And I think sometimes we forget about the less used ones, as you can see here. And the second bullet point, the CE 60.1.19. So there are 19 CEs listed. Just have a quick skim through. As I say, if you're notifying a CE, just to make sure you've included them all, and then you're not missing out on a few gems. So here I've listed the potential CEs that you might be relying on in a COVID situation. So the first and most obvious one is prevention, which is, as I said, clause 60.119. It's very similar to a force majeure clause, but it's wider, and it's wider in two respects. First, it covers, it's not necessarily related to not being able to complete a project, which sometimes force majeure is. It's talking about not being able to complete it on time, and it's related to a situation occurring that neither party could have anticipated or foreseen at the start of the contract. So that's where you need to be careful now with the contracts you're entering into, because if you're entering into a contract today, COVID is absolutely something you would be aware of or should be aware of. So the likelihood is that this clause 19 probably won't help you. The next one that is a possibility is a change of law. Now, potentially you could rely on, the requirements, but of course the law, as in the coronavirus regulations, did not at any time require construction to stop or construction on site to stop. So I can't think of any situation where you are going to be saying that the coronavirus legislation entitles you to a compensation event. What we might see is people using it to say, for example, I'm a contractor, coronavirus legislation came into force, all the suppliers closed down in the mistaken belief that they had to close down, and didn't reopen until the government confirmed that actually they shouldn't close down, and therefore that change in law sort of caused a compensation event. So I could see somebody running that argument, but it's not really what's intended. It's intended to be used where there's legislation that stops work on site, which hasn't ever happened. Also bear in mind a couple of others. So 60.12, where the employer, the client, fails to allow access. Obviously, that would apply to a subcontractor under a subcontract if subcontractor was told by the contractor, don't bother coming to site, I've closed the site, or clients closed the site. And also 60.14, where the project manager instructs the work to stop. So there are a couple of others where you might particularly want to use them. I mean, if those scenarios apply, my view is when you're notifying a CE, notify all of them. You can't go wrong there. So you might be notifying, 19, 2 and 4. So that would be my advice. In particular, check your NEC contracts, because quite often what you see is that CE 60.119 is amended so that it's more analogous with the JCT. So it's amended so that you get additional time but no money. So in that circumstance, you might want to try and bring in those compensation events 2 or 4, if they apply, or if you think they can apply, in order to get the additional money as well as the additional time. Also, not included there, but consider using 60.11, which is probably the most used compensation event, and it's basically where there's a change to your works information. So, you know, you might be able to find something in the works information that allows you, you know, access at all times or something like that. And if you're prevented from accessing site, you could use that to say, well, it's a change to the works information. Now, you know, as I say, you know, these become particularly relevant if your CE 60.119 has been amended. But, you know, as you know, I've said, you know, I would just put in any CE that you think could possibly apply. You know, there's no harm in over notifying with your CEs. You know, you're always going to come across a problem if you under notify. There is an issue with termination if compensation event 19 applies. This isn't really relevant, as we've seen so far, because it really only applies if you can't proceed with the work for a certain period. Whereas, of course, this didn't happen with COVID, and hopefully we're coming out of COVID now. It's not going to be so much of a problem, so it's not going to apply. Just be careful with this, because if there is a termination because of compensation event 19, it results in the contractor getting no loss of profit. Well, no losses for overhead or profit. Whereas if the employer terminates at will, so just decides, you know, I'm just not going to proceed with this, then the contractor would be entitled to its losses with regard to overhead and profit for the part of the work that doesn't get completed. So just bear that in mind if that happens. It's I mean, realistically, it shouldn't be happening. Contracts shouldn't be being terminated for reasons of COVID. So steps to take, you know, as always with these things, you know, when things happen on site, you know, there is a huge opportunity for both parties to work together, and that's what you're required to do under NEC, to try and mitigate the losses. You know, it's a sensible way forward. You know, why wouldn't you do that? But also, you know, even if relations aren't particularly good on site, you know, it's the right thing to do, because if you're going to end up in a dispute, it's always good, you know, to have that documentation to show that, you know, you tried to liaise with the client, tried to find, you know, ways forward of dealing with things, because it then means that it's really difficult for them to come up with arguments that, you know, oh, well, you know, a contractor could have done X, Y, and Z to mitigate loss, but didn't, because contractor can say, well, you know, we tried to liaise, we were trying to communicate with client, with project manager, and trying to find a way forward, but you know, they wouldn't negotiate. So again, you know, discuss and liaise with the client. If you're a subcontractor, you know, it applies to the contractor. You know, if that's not going anywhere and it's not documented, you know, put it in writing so you've got it documented. Issue an early warning notice, so that's under clause 16.1. Do it immediately. You know, don't wait to discuss or liaise. You know, issue your early warning and then try and discuss things, because you can absolutely bet your bottom dollar that if you don't, because you're trying to be collaborative, you're working together, etc., that will be used against contractor or subcontractor if there's a dispute later on down the line. And it is a contract requirement. You know, all you're doing is complying with the contract by issuing it. Also, again, notify the compensation event. Again, it's a contract requirement. You are required to do it in most cases. For some compensation events, it's not the contractor or the subcontractor's obligation. But again, I always say, if in doubt, just notify a compensation event, and then you don't face arguments later on down the line. Contractor should have notified, didn't notify, and therefore is precluded from any additional time or money. I say this every seminar, these are really nasty clauses, these. If you don't notify a compensation event in time, you're not going to get paid any extra money or extra time, but you've still got to do the work. So please notify. 8 weeks of becoming aware of the issue under the main contract. Under the subcontract, it's less, and I think it's 7 weeks. I can never remember this. It's either 6 or 7 weeks. So subcontractors, please note that. Also, subcontractors and contractors, check that your contract hasn't been amended, because so often that time scale is reduced and quite often it's halved. So just make sure that you comply with that. Check your service provisions. Usually under NEC, email is fine. Generally, if you're issuing an early warning notice or a CE with NEC, what we find is we have pro formas anyway, but just make sure that you're not required to issue by post. And obviously mitigate your losses, already touched on that. So, at one point that involved, putting people on furlough, considering alternative projects, etc. Okay, so JCT, slightly different, because whereas with NEC we have compensation events which deal with any extra money and any extra time, so that includes change of work, so that's your compensation event 60.11. It also includes extra time and money relating to that time. With JCT, we've basically got 3 areas to look at. So the main one is extension of time, so that's in the design and build contract clause, so that's D and B, clause 2.26. In the other forms of contract, it's in a similar place towards the end of clause 2. We also have variations generally, so that's sort of the equivalent to your 60.11 in NEC, and also we have loss and expense provisions. We'll look at them in a minute, but that's where you recover your money with regard to time. So a bit more convoluted here, because you really need to think about notifying all elements, which isn't particularly efficient, I don't think, under JCT. But just don't forget about them. So when do you get an extension of time that might be relevant to COVID? Well, a change in the law, very, very similar issues to NEC, not particularly relevant because we haven't really had a change in the law that has impacted upon construction. Force majeure, which is kind of effectively a prevention due to an irresistible force. Now, force majeure isn't actually defined in the JCT form of contract. So you're kind of left using the dictionary definition. What you might find is that your JCT contract has been amended by your client to include a definition. So if you're making a claim, you just need to check that to make sure that the definition, the defined term in your contract does include a pandemic. I'd be really surprised if it didn't. But again, timing of your contracts, this will work for contracts entered into certainly before February last year, hopefully before March and April last year, but contracts that you're entering into today, that you entered into June last year, it's not necessarily going to help you here. Also, just be careful of a trend that's going around JCT where it's amended. Actually, it's happening in NEC as well. It's amended so that there's a clause that says that if there's any concurrent delay, where one delay is the client's risk, so all of these delays that we're looking at, but the other delay is a risk of the contractor or subcontractor, then it's the risk of the subcontractor or contractor that applies, and we ignore these risks. So be careful of that clause. Just generally, it's not necessarily just in relation to COVID, and just be aware of what it means. Typically, it will say that contractor, subcontractor doesn't get an extension of time. So, if you're not happy with that, you need to amend that clause out generally, but, also beware of it in this COVID context. So loss and expense. So this is where you get your money in relation to the delay, as opposed to just the extension of time. So what we're looking at here, they're called relevant matters, and they're set out in the design and build contract at 4.21. Again, it's towards the end of part 4 of the contract, and in other forms of JCT, it's again towards the end, but not precisely at 4.21. So the bad news for JCT is that you don't get any loss and expense for a change in the law. You don't get any loss and expense for force majeure. So this is why, you might want to, consider the wider context and have a look and see if there are any other issues that are causing the delay, causing the loss and expense, and claiming under them rather than under COVID, so that you can get the loss and expense as well. And we'll come on to that. JCT suspension and termination, very, very similar to NEC. So if you're using the force majeure clause and the suspension continues for more than 2 months, then either party can terminate. So I'm not going to kind of dwell on that, because it hasn't really happened as things, have transpired, but just be aware of it. This force majeure clause isn't necessarily, a win-win for contractors and subcontractors. It gives you very little benefit, gives you a short extension of time, gives you no extra money, and potentially it gets you a terminated contract, which isn't great news. Be careful with your JCT form of contract. This is the design and build at clause 1.7. The other contracts, it'll be in a similar place, but not necessarily at 1.7. But it's about service of notices, not quite as user-friendly as NEC, because JCT still talks about serving by post, using special delivery, etc., and recorded delivery. So just be careful about that. Also, service of these documents with NEC under the standard provisions where it's unamended, you can serve by email, and the date it's deemed to have been served and received is when it's been sent by email, whereas of course with post it's the second business day after posting. So just be careful of that if you're on a strict deadline. The final bullet point where I've said email also to all, what I mean by that is that's not under any circumstance to think you can serve documents by email. You would need to have the JCT specifically amended to say that, and it might have been, but you just need to check. What I'm meaning here is that if you're delivering something by hand, by recorded or by special delivery, what I would always advise is to also email it to the relevant individuals who you commonly deal with, because of course the whole purpose of serving a notice is to notify someone. So if you are posting things to them. I always think it's a good idea to email it, because they have then been notified. It might not have been through the proper method, but they can't then say, oh, something was delivered by hand. Our office had effectively shut down because we were all working from home. We didn't receive it. This is sharp practice by, the person who sent it. So my advice for things like this, for notices where you are trying to bring something to their attention because you're required to under the contract, to always also submit it by email. So what are the requirements? We've seen with NEC that you've got to submit your early warning notices as soon as you become aware of something. You've got 8 weeks under an NEC contract to submit a compensation event from becoming aware of it. The JCT is slightly different in that it's not as clear cut. What you will find is that I would say 80% of JCT contracts are amended to make it a bit clearer. The timescales here are usually tighter, so typically you will see 7 or 14 days in amendments. So that is the timescale for you to notify these issues. Now, the clause at the moment says that you give notice forthwith. So, effectively that is immediately. It's not particularly helpful because what we like to see is a timescale. So, again, I would just, if in doubt, notify and do it as soon as you're aware of it. It is forthwith upon you becoming upon it becoming reasonably apparent that there's a delay. But if something happens COVID wise, half the people on site have to be put in quarantine. You're going to realise pretty quickly that that's going to cause you a delay. You haven't got too long for it to become reasonably apparent. You've also got to give particulars of the expected effect and estimated delay. And then if it changes, again, there's an obligation to notify. So this obligation to notify is really just, keeping the contract administrator up to date, keeping them informed. So if you think about it like that, but it is a notice, it's a formal document that needs to be issued. So just keep your eye on that, make sure you comply, because there is case law that says if you don't comply, again, same implications as for NEC, you don't get that extra time. And if you're entitled to it for loss and expense, you don't get the extra money either. So for loss and expense, and query whether we're going to have a loss and expense claim here, because of course, for none of the strict COVID elements of extension of time, you're not going to, for those, you're not going to be entitled to loss and expense. But again, the same requirements for notification. It's, you've got to notify forthwith upon it becoming reasonably apparent that loss and expense is going to be incurred, and thereafter monthly updates are required. So again, think of it as updating, make sure you do it. Why wouldn't you? It might not be a welcome notification, but it's what the contract says, therefore it's what the contract administrator, it's what the client wants you to do. So, if you're having issues, so this is leaving site, but probably more things are slowing down on site for whatever reason due to COVID, immediately issue your early warning notice, notify your compensation event. It's probably going to be under 19. Issue your quote. This applies to all quotes, not just for COVID, but, please remember your extra money, the time related money. But also remember to ask for your extension of time, because you don't want to find that your quote's accepted and that you haven't asked for the extra time, because then that could cause you real difficulty. You could find that you just can't go back and ask for the extra time. And also don't forget, if you've got key dates, you need to be asking for extra time for those. So there is a shopping list of things that you need to be asking for in your quote. It's not just about the money. If you're instructed to leave site and you're on an NEC form of contract, so this could be, any kind of reason where, clients asking you to leave. So, think about scenarios where, other parties, there's been a COVID outbreak, so the site's been closed because of that. Whatever reason it is, if it's COVID related, or you're being told it's COVID related, just, again, read through all the compensation events and consider which ones you might want to use. But issue an early warning notice first of all. You don't even need to think about which compensation events there might be. Just get that early warning notice issued, because the chances are, if you're being asked to leave site or you're slowing down, there is going to be a delay and there's going to be extra money, so you must notify. What you might want to notify are compensation events 1, 2, 4 and 19, the ones we've discussed. As I say, look at others. There's also one, I think it's 14, which is employer's risk. So you might just want to chuck that one in and say, well, this is employer's risk, particularly if, they're saying there's a delay and it's due to COVID, but you're not quite sure whether that's a bit of a smoke screen, on this, and it's not really COVID that has caused the delay, that it might be something else, or it might be bad management with regard to COVID, which is, to me, quite distinct from COVID causing it. So notify those CEs, and again, issue your quote. Strictly speaking, you should be asked to issue a quote. It's your choice as to whether you want to issue one if you're not invited to, but I think it's quite a good thing to do. So JCT, if you're leaving site or slowing down on site because you have a COVID issue, you're notifying force majeure, notify loss and expense. You're probably not going to be entitled though, and beware of the 2-month suspension, which might lead to your contract being suspended or terminated. JCT again, if you're being instructed to leave site or things are slowing down. So again, this is a scenario where you might be being told it's COVID, it might actually be bad management in relation to COVID, or it might be that, COVID isn't actually the real cause. And with quite a lot of these, you might not actually know. So just keep your options open. You have to be a little bit suspicious, maybe, just because your client is saying this is COVID. Don't necessarily believe that unless, you are absolutely sure, because, you've seen the evidence, etc., that it is COVID. So, keep your options open, and notify extension of time. You might want to throw in the grounds in the relevant events, which are an impediment by the employer. So you might just want to put that in, because of course that does get you loss and expense if the employer is preventing you from progressing your work, which is what's happening if you're instructed to leave site, or if you're being delayed. So I would put that in as a default if the employer is saying it's a COVID incident, because it then gives you a kind of foot in the door to say, well, you know, I need to see some evidence, some proof that it's COVID and it's not something else. In the same way as, to be absolutely fair, your client, your employer would do to you if you were saying, oh, excuse me, can I have an extension of time for X reason? You know, it's exactly the same point. You might also want to notify a VO, a variation under clause 5.1.2. So similar to a compensation event under 60.1.1, where you're saying it's a change to the works information. JCT says that it's a variation if the employer restricts access, restricts working space, hours, or order of work. So bear that in mind. You know, I would put that in as a notification as well. You know, not least because I suspect it will get some communication going, because probably the employer will come back and say, what are you talking about? This isn't a variation, this is COVID. And it gets the discussion going, doesn't it? So that's everything for today. I hope it's been helpful. I hope it's, you know, given you some useful tips. I think we have some questions. What I would say is, lovely, thanks, Gemma. If you do have to go, before we get all the questions dealt with, and your question isn't dealt with or whatever, you know, do email me and I will respond. Please, what I would say is don't telephone me on my landline, because we're not working in the office yet. Right, so first question. One of the sites got delayed due to outside stakeholder, couldn't access the rail due to staffing. Rail freight takes priority. This made the scheme. I'm not sure whether this is a COVID related question. Whether, I mean, if right, so I'm assuming PMI, yep, so it looks like it's an NEC form of contract. Right, lovely.
This was a follow-on. Sorry, Sarah. This was follow-up to that.
No worries. No worries. I mean, I mean, what I would say is I would go back and say we've had a project manager's instruction to stop the works. I'd have a rummage around the works information, and, you know, what I would say is, you know, the works information doesn't envisage our works being stopped. So it's a change to the works information. I'd use all the other compensation events that you can. So there are a variety, such as, you know, not being able to work in accordance with the accepted programme, all those kinds of things, and submit the CE. And assuming your client is saying, well, you know, this is because of COVID, you know, you need to be satisfied that that is the case. You know, this isn't a sort of magic wand where, you know, clients can just say it's COVID, you know, this is my get out of jail free card, and you've got to accept it. So if you look at it the other way around, you know, if you were wanting an extension of time or a compensation event and you just said to your client, oh, you know, I quite fancy an extension of time, you know, can I have one, please? They'd be saying, why? Give me the evidence, you know, what's happened? Why do you say that, you know, you're entitled? All those points, all those questions now apply the other way around. You need to be satisfied as to why this project was put on hold, and it's not really clear here, unless, you know, the railway was going to close, the rail line was going to close, but for your works, it had to stay open for some reason. So, you know, I think you need to start submitting some notification of CEs and asking some questions about it, to find out what, you know, how this all relates to COVID. Okay, Craig, NEC4, congratulations, how exciting. That's like an exam question, Craig. I think the scope there, because your contract was awarded the middle of March, so you're on the cusp there, because from recollection, the regulations, you know, we had the talk from Boris saying he was going to introduce the regulations probably about the 18th of March. So you might just have signed your contract just before Boris announced the lockdown. So you might be okay there. In which case, you know, I think you should be entitled to your additional welfare facilities, yes, because it's COVID related.
Okay, you might... we've got one other question, Sarah. I'm going to put it up. It's a very long one.
Oh no, I have to do lots of reading. Can I just say on that last question, Craig?
I may have to scroll down.
You start, the date you started the works is really irrelevant. It's when you signed up to the contract. So, you know, don't be worried by the fact that, you know, you actually started the works in April. That sort of helps you because, of course, we were into lockdown then. So you probably definitely needed your additional accommodation. Working under any, although sites not closed productivity. Yeah. Yeah, you see, I think that if you're on NEC, if you've got that compensation event 19, I think that should entitle you to claim all of that, because what you're saying is effectively all the contract timescales are moving out, and you're incurring additional costs because of it. If your timescales aren't moving out, I'm just trying to. You might be able to claim under by just saying it's a change to your works information, because where would all of this normally go? I'm just kind of thinking out aloud. It would either have to be information in the works information or in the site information. I would have thought probably more in the works information. So I think that's definitely worth putting in a claim and saying, this has all resulted in, extra cost. Where I can see you may come across problems is if you have provisions to say that, you are required to comply with the law. And of course, then it comes down to when did you enter into your contract? Because if you entered it into the contract, say in June last year, we knew about the restrictions. So you knew as a contractor there were various provisions you needed to comply with the law. So that might be tricky. If your contract predates March, April, then you're probably okay, because it wasn't the law at that point. I'm trying to think if there are any other, because this one seems, well, no, you're saying productivity has been affected. So actually, if there's been any slowdown, you're probably okay with 19, CE 19. What I'm thinking about is a situation where contractors maintained productivity, but, you know, has this test and trace cost. I guess, of course, you know, the testing is really expensive as well if you're having to test people. So yeah, it's going to be slightly different if you're not being delayed or disrupted, but you've just got that extra cost. So I think there you're going to have to be looking at, I mean, I'm not saying don't submit a claim under 19 under NEC, but possibly look at other provisions. As I say, works information, so compensation event 1 is the one that springs to mind. So, you know, there's nothing in the works information that requires us to do the test and trace, blah, blah, blah.
Okay, I think that's it for questions, Sarah.
Yeah, hopefully you can see from this that we're going to come across as we go, you know, through this, you know, different scenarios, you know, and some of them I suspect will end up being referred to the courts. So, you know, keep an eye out for that. You know, as it comes back to this point that I made, you know, as a lawyer, it's an interesting situation for us. Probably not so interesting for you guys because you just really want an answer to it all. But you know, the courts are going to be looking at these things, and causation is very, very key to it all.
Okay. Thank you very much. I think that's it for our questions. Huge thanks again to Sarah for another fantastic webinar today. I think this is something that we'll probably need some kind of regular updates on, Sarah. I'm sure you'll be on top of the case law with this one. And it's nice to see questions that are, you know, 3 paragraphs long. So we may need purely a question and answer session next time. But thank you very much. Thank you hugely to everyone who's come along again today. I hope you found that useful. As I mentioned, I'll get a copy of the slides out to everyone who's attended today, and a copy of the recording to everyone who's attended and registered and couldn't make it along today. So we look forward to seeing you at our next event, which will be next month. You should all receive an automatic invitation to the next webinar that's coming up. But if for any reason you don't, please feel free to drop me an email and I'll get back to everyone. Okay, thank you again, Sarah. Thank you, everyone, and we look forward to seeing you at our next events. Take care, everyone. Stay safe.
Thank you.
Thank you.